you after you get the listing. So I'll turn it over to you, Justin.
Thank you. I'm going to film this just so, and I'll send it out to you guys and send it out to Kerdyk. So if there's other people who want to watch that, maybe weren't able to come for whatever reason, so you might be in the video a little bit, but it's all right.
I'll move back there.
So first, thank you, William and Kerdyk, for letting me come. So my name is Justin Stivers. All I do is probate law. So I have a law firm in downtown Miami. But we operate statewide, and all we do is probate. We don't do title, we don't do closings, nothing but probate. So the purpose of this course and kind of, what I title it is Probate 101 for Realtors, and it's really threefold. One, give you guys just enough knowledge so that first, I want you to be able to know when to spot a listing or a property that might need to go through probate. So the first is this course is not, you haven't already gotten the listing yet. This is, maybe you're prospecting, maybe you're cold calling, maybe you're knocking doors, maybe you get a referral and someone says, hey, someone's passed away, can you help them sell their property? So this is to help you identify whether or not probate is even necessary. So then you've identified, okay, yeah, probate is necessary. Now you're going to go to the listing agreement or listing presentation. I want you guys to have just enough information so that when you go there, you all can sound intelligent enough. I mean, you all are not attorneys, I don't think. The client doesn't care. They don't want to hear the process. Even my clients, they don't want to hear the process of probate. They basically, want the end result. So the goal is to give you guys just enough information so that when you go, you can use some key terms and sound like you know enough about probate. And then lastly, I want to give you all just a couple ideas to how to market for probate properties. What industries, what professionals, because obviously, I think at the end of the day for you all, it's really about getting listings. So, all right, so before we get started, that's me. I just want to go around the room. We got a small group, so just, if you would, so I kind of can gauge who we have here, name, how long you've been a realtor. Maybe you can say if there's anything you focus on specifically within, your market. And then if you've had any experience working with a probate property or a listing or representing a buyer, seller, and then what that experience was in probate. So I guess start back here. Or you were eating, sorry.
No, I'm good. My name is John Guzzo. I am a commercial realtor. I don't do a lot of probate-related work, so I'm here just to learn.
Okay, cool.
Whatever, Sean.
My name is Rochelle Kaplan. I'm mostly a residential agent. I have had listings that were in probate, but they were just always given to a probate attorney, so I really didn't know what was going on in the background.
Okay, great.
Ed Bowen in commercial also, and have several times been involved, but it was just, here, take the listing,
Right.
it's in probate, and that's it.
Okay.
Trey Kerdyk. I think I've been doing real estate for 3 years now. And pretty similar to Ed and Rochelle. That's how most of my probate listings have come to me, is just through probate lawyers. And,
Okay.
Personal, interactions, I guess, with, whoever was going through the probate.
Okay, cool.
My name is Brian, and right now what I specialize in is lead generation, and that's what I've been working on recently. I do both residential and commercial, and I've never had a probate deal before, so if I could generate leads like that would
Sure.
be great.
Okay.
So William, and I've had a bunch of probate deals. Most of them have been fairly easy to deal with. A couple have been challenging. I had one where I think it was in a guardianship at the time, and the lady died, or passed away I should say, and then that held up the closing, and then those buyers walked away, and it was a big pain.
So it was a mess.
And then now we have another one that has been ongoing for like 3 months now too. That's
Okay.
At least 3
but
months.
yeah, I mean, for the most part they've been fairly smooth, but a couple of them have been not so
Headaches,
smooth.
right.
Yeah.
All right. Okay.
Hi, I'm Lourdes.
Hi,
I've had
Lourdes.
my real estate license for about 20 years,
Okay.
but actively on and off, maybe about 3 years. I just joined Kerdyk
Okay.
in March of this,
18, 17.
March 2018. No, 2018.
Okay.
Oh, almost a year. Yeah. So
Alright.
I have been on the other side of the of the transactions with the law firms and the probates and so forth. So I am looking forward to learning on this side of the
Sure.
of the deal.
Okay. So, yeah, go ahead.
I did have one where it was under contract and the husband died, and it wasn't a lot of trouble, but the property was only about $400,000 or $500,000 many years ago. It'd probably be $7 million today.
Oh, wow.
In the
Okay.
area that it's in, it was a home in the moorings and an extra lot to build on, but that was interesting. So I just sat back.
Most of you, it sounds like, have had some sort of experience with probate, but more so on the end of it was referred to you, so you didn't really have to find it. And maybe during the ones that were referred, were you kind of already in with the seller, or was it the attorney or professional who hired you, so you didn't really have to do a listing presentation necessarily?
Yeah.
Yeah.
Okay.
Attorney and on the buyer side, you know.
Thank you.
Okay.
For family member,
Okay.
there's deceased.
Just take one. So this is, I know you guys don't really have any boards or anything to write on. It's a very simple, handout with just some key definitions, and then these are basically, so the three kind of topics that I was going to discuss: how to determine whether probate is necessary, how to successfully guide your clients through the probate process, and then how to market for properties in probate. So feel free to take notes, and I'll at the end I'll send you all information as well after this. But okay, so it sounds like so you guys have some working knowledge of probate. It sounds like a relatively experienced group of realtors. You guys have been doing this for a while, or at least had your license for a long time. So I won't, if at any time you guys just have questions, feel free to just shout them out at me. We're a small enough group. I've done this presentation a couple times, and I know, some of the stuff you might already know, some of the key terms, but there might be things that you have other questions about. I'm trying to keep this, just very broad. I don't want to get, too into the weeds. I mean, I could, talk for several hours about the law of probate, but that's going to bore you all and probably not super necessary to what you all do. But if there are specifics you have questions about, feel free just to shout them out. Okay, and then this is probably going to take, with this size group, probably 30, 45 minutes or something, depending on questions. So I won't keep you here real long. So a couple key terms. Probate. So the term probate in general basically just means it's a court process. So anytime you hear the word probate, there's a court involved, there's a judge involved, and there's probably going to be attorneys involved. The way I kind of explain it, our kind of tagline is we help people get their inheritance after the loss of a loved one. So it's really the triggering point. Someone had to have died, okay, and that person had to have had some sort of asset. In your case, it's a piece of property. So usually what happens is John Smith dies, he owned that piece of property. Now it's owned by the estate of John Smith, and you have to go to court, and at the, then the attorneys, we do a process, and at the end of the court, the judge is going to give you a new order saying who now owns the property. So anytime you hear the word probate, there's judges involved, there's courts
What
involved.
if there's only one family member, and that's the only family member of the deceased? Does it still need to go
Yep.
to probate, or it
Yep.
doesn't just automatically go to the
Yeah.
one family member and it gives them the right to sell it?
No.
It has to go.
Has to go through probate. There are, and I'll get into it a little bit, there's really only a couple ways to avoid probate, and I'm just going to talk specifically about property because that's, what's most relevant to you all, but is if the property was in the name of a trust, so if the trust was done properly, or depending on the deed, there's a couple different deeds, a ladybird deed, if you all are familiar with, or a joint tenants with right of survivorship, and I'll touch on those a little bit as well. But for the most part, if someone passes away and they own property, I would say 9 times out of 10 there's going to be probate involved, even if there's only one person. Decedent, so that's just another term for someone who's passed away. Just a dead person, I guess. But decedent, that's a term we use pretty often. Estate, so the estate, so like I mentioned before, the estate of John Smith. The estate, the way to think about that is really any assets, any liabilities that the person had when they died. So it's kind of like your new name. So when John Smith was alive, he was John Smith. When he dies, he's now referred to as the estate of John Smith. So it's kind of all-encompassing. Everything that John Smith had, he's now the estate. That's what the estate is. Last will and testament, probably most of you all are familiar with that. A last will and testament is a document. It could have been, downloaded off the internet. It could have been, handwritten, but it's basically what the person wants to happen with their stuff after they die. So, there are certain, I'm not going to get into the requirements unless you all have specific requirements about what is a valid will or not, but I could write down, I leave all of my property to William Colas, assuming that it's done property. I label it a last will and testament. That could be my will.
And it has to be notarized.
It generally needs to be notarized, and it has to be witnessed by two people. That's a whole nother topic, but there are, other states have different requirements, and Florida will honor wills of other states if they're within certain requirements. One thing to know is, and this is kind of a misconception, a lot of people think that a will, so if I just, again, let's say I die and I have a will and I leave everything to Mr. Colas, he cannot go to Miami-Dade County and say, listen, Justin left me this piece of property, here's my will, here's his will and testament, the property's mine. A will doesn't avoid probate. So even if there is a will, you're still going through probate. And a lot of people think, yeah, but my dad had a will, my mom had a will or whatever, they said I get everything, I'm the only child, but a will alone does not avoid probate.
Is there a certain type of will that will keep you from having to go through the probate process?
A will, no, but a trust will.
A trust.
A trust is a different
Irrevocable. Or
there's a bunch of different types of trust, and I'll show you some samples. But generally, yeah, a trust, if it's done properly, a trust is a different type. It's more sophisticated than a will. A lot of people, it's common, they'll do their own will. They'll download it, or there's a bunch of websites you can get wills from. But a trust is a little more complicated. But a trust would avoid probate. And then the last term I have on here, personal representative. So the personal representative is the person basically in charge of the probate. All right, come on in. Yep. The personal representative is the person that you all, as the realtor, would be working with. So it's basically the person. I'll give you this. Yes, ma'am. That is either named in the will. That's going to be the person who has the authority to sell the property, that has the authority to do, basically the personal representative is that I, as the attorney, that I would be working with. And I have their executor, so that's another term you might hear, but different states use different things. So in Florida, we use the term personal representative. I think New York uses the term executor, but they mean the same thing. Yeah.
Is probate done on a county level or on a state level?
By county. So basically, you're going to file the probate usually where the property is located.
Okay.
So
might you have to go through probate in different counties if, say, someone owns a bunch of property in Miami and a bunch of property in Orlando?
Yes and no. I mean, I'll give you an example. We did a probate here. Their primary residence was here in Miami-Dade. We opened the probate. The person died in Miami-Dade, but they had a piece of land in, I think, Columbia County, and so a small piece of land there. We didn't have to open the probate in Columbia County. What we did is here in the Miami-Dade court, we just had the judge, in this case, say, this property now goes to these people, and then the personal representative can create a new deed. So we did a deed and had it recorded in Columbia County, and it was fine. So generally, that's how we do it. Sometimes each clerk is a little bit different. I mean, each court system is a little bit different, but generally, yeah, if you're in Florida and you've got multiple properties, the main probate is going to be opened where their main residence was. And then if they have other properties scattered throughout, you're probably just going to do a deed in that specific county, but you're probably not going to have to open a separate probate. Okay. Any questions about terms or anything like that? Okay, great. So how to determine whether a probate is necessary? So like I said, this is, if it's coming through an attorney or, maybe a CPA or something like that, probate is necessary because the probate attorney is telling you. But what I find is a lot of times a realtor, they'll call us and they'll say, maybe they were door knocking is common. They're door knocking, they're calling expired listings, or maybe I think you had an example, like a friend or a family member says, hey, my cousin or whoever wants to sell the property, their dad just passed away, and you're not sure. Maybe probate is necessary, maybe probate isn't necessary. I guess I'd ask you all, when you all are getting ready to look up when you're getting ready to maybe go to a listing presentation, someone says, hey, I've got this property down on Ponce, what's the first thing you all do? Well, one of the first things you all do.
Look it up in the public record.
Yeah, look it up on the property appraiser's website. So that's the first place to start. And so I was just going to give you all a couple examples, but this is probably the easiest way to tell. So there's a couple different examples. So these are all probate cases that we're handling. So this one, if you look at the owner, you'll see that it says estate of. So Maria Pichardo, EST of. I never, as an attorney, I can't ever say 100% of the time, but almost 100% of the time, if you see the owner listed as that most likely means it's got to go through probate. So Maria Pichardo is the person who passed away, and again, this is one that we're doing. So this property cannot be sold. So if you find this listing, you get the listing present, you get the listing agreement, you get a buyer, you go to close, everything's good. Title's going to come back and say, no, you got to fix this first, and the only way this property is going to be sold is if it goes through probate.
So is there a way to determine whether it's gone through probate or not by looking at the tax roll?
So yeah, that's a good question. So what you could do is you could go on if you know this county, you could go on the court's website, the clerk of the court website. I don't know if you guys do that at all to look up stuff.
Right.
And you could put in this person's name and see if a probate is open. But even then, that's not a sure thing.
Gotcha.
Like for example, this one, we already got title transferred, and I just printed this off a couple days ago. And this property is now owned by this person's daughter. But the property appraiser takes like a really long time sometimes to reflect the change. So you might not. I would say 9 times out of 10 though, if you see this, it's probably not in probate. I mean, we just got it transferred, so I think they'll probably reflect the change. But if you see this, it's good to just note that it's probably going to have to go through probate.
How long does it usually take to go through a simple probate?
That's section number 2. I will answer that. Yeah. So this is if you're looking at the property appraiser's website, you see this is generally going to be one that's going to go through probate. Here's another common one where you're going to have. This is another one this one is not completed. We're in the process of doing.
Do these people usually have wills, so they don't have wills, they have nothing?
Sometimes they do, sometimes they don't. But like I was saying earlier, I don't remember if you walked in, a will itself will not avoid probate. So even in that one that I just gave you, I remember she didn't have a will. But even if she did, even if she had a will that said, I leave this house to my daughter, it's still going through probate.
So why? Why is it going to? I had my mother, and we were a whole bunch of people under a little stinky house.
Right.
And we didn't have to go to probate.
Was it in the name of a trust?
No, it ended up, and I had to put it in a trust, but because we rented it for some time, but we never went to probate.
I don't know enough about it, but I can say 100% that if there was a will, it's not going to avoid probate. If you guys put it in a trust before she passed, then it would avoid.
It was after I put it in a trust.
I don't know enough. Maybe title's not done right.
No. The property has already been sold.
Okay, yeah, I'm not sure. I don't
Everything's in
know.
order.
I'm not sure.
And this happened in 29, 09, so I mean, it's done and over with.
Yeah.
We didn't have any problem.
Yeah,
But
I
it
don't
will-
know, but because I can say almost 100% that even if there was a will, it's not going to avoid probate. So maybe the deed was done properly. Maybe she had a deed that left the property to you all.
We were a whole bunch, 5 of us and 6 grandkids.
Yeah, I don't
I
know.
had to do a trust for all those people. I
Yeah.
did that.
So this second one that I just gave you guys is, you'll see it shows Jesus Silva, EST of, and Maida Silva. So this is an example where, again, this is actually owned by 2 people. It was owned by 2 people. So Maida owns 50% of this property, and the estate owns the other 50% of the property. And Maida can't sell this. I can tell you because I'm doing it right now. So we just got it approved, the sale approved, so she's going to be able to sell it now. But we had to do the probate for Jesus. So we had to first probate his 50%, and now she just happens to be the daughter, so now she has 100% ownership, and now she can sell the property.
How much does a probate typically cost?
Also going to do that in the second one. Yeah. So
But
yeah,
it's
so
not the same husband and wife. You wouldn't have that problem, right?
if husband and wife, generally no. If the deed is done correctly, then it's going to say as husband and wife, and the deed just goes right to
whoever
them.
is alive.
Right. Yeah. So this is something you might see, and a lot of times in this example, let's say that you come across Maida, and Maida wants to sell the property, and let's say they weren't family. Let's say, for whatever reason, she was on title, she was on the deed with somebody else, which happens. She might want to sell that property, and she's going to say, but look, I'm on, I've got title, she can't do it until the other 50% is probated. So that's something that is, I see, pretty common. And the last one that I'm going to give you.
What happens if one of the parties does not want to sell the property?
Then you have a whole other issue, which is a partition action, which is to basically force the sale of it. All right, and pass this around. And this one is this is a property that was properly put into a trust. So you'll see on here Karen S. Rodman, TRS, and what this means is this is not going through probate. So I'll get calls every once in a while. A realtor, they'll see this on the property appraiser's website, and they're not sure what it means. Sometimes, this is just one example. Sometimes it might spell out. It might say Karen S. Rodman as trustee of the trust of yada yada yada. But just TRS is a common acronym for trust. So you might see this beneficiary.
Oh, beneficiary.
Yeah. So that means she is a beneficiary of the trust. So this is something that if you were to come across this, yeah. So she probably just put the trust in her name herself. I didn't do this. But yeah, this is something common too. So if you came across this wouldn't go through. This wouldn't go through
It
probate.
wouldn't need to go through.
No.
Which means that the
They can sell
trust can sell it
Yep.
straight out as a.
Yeah, barring any, depending on what the trust says, maybe there are some, for residential properties, it's not, you generally don't have complicated trusts. Maybe for you all, if you're dealing with a big commercial building, you might have, whoever made the trust doesn't want you to sell the property unless you have, it has to sell it to a church or something. You could come up with different requirements, but generally just a normal trust, yeah, you could sell it. Okay, so all right, so step number one, you've looked at the property website, appraiser's website, you know that it's going to go through probate. So now you go meet this person. So there's a couple questions you want to ask them, and the reason you want to ask these questions is you want to make sure you're speaking to the right person. So the first question you want to ask when you go and you have this listing presentation is, was there a will? If there was a will, can they get a copy? Do they have a copy of it, or can they get a copy of it? So I told you earlier that, we've been saying that a will doesn't in of itself avoid probate, but a will could say who gets the property. So let's say that you're talking to the son, and the son is yeah, I want to sell this property. I've been living with my dad. I was taking care of him. He was sick, yada, yada, yada. Okay, great. Did your dad have a will? Yeah, he had a will. Are you the beneficiary? No, actually, the will says that my sister gets the property. So you want to make, when you're speaking to them, you want to make sure you're speaking to the right person, because if you spend all of this time speaking to, let's just say, Dave, and Dave actually isn't the beneficiary of the will, you're not speaking to the right person. So always ask if there was a will, and then if he or whoever says, yeah, there was a will, ask if they can get a copy. Because one of the things that I see is, they say, yeah, there was a will, I get everything, but I can't find the will. And, me, that's kind of a red flag to me that maybe this person, again, is not the right person you're speaking with. The second question that I think is, really important to ask is, what's your relationship to the person who died? I get a lot of, I'll give you an example. So an investor called me, he found a probate property, or a property that needed to go through probate. He's been speaking this woman, gets a good deal on it. She's ready to sell. He finds out it needs to go through probate. I start speaking with her, and just something goes off. Something triggers her. I'm like, this lady just doesn't seem like, she seemed too far removed from the guy who passed, the decedent, didn't know enough. As we go along, finds out she has no relationship to the person who died. So she's in no position to sell this property, and she was just kind of trying to get money out of this investor. This is, that's sort of an extreme case. That's not going to happen, a whole lot. And truthfully, this investor should have been a little more savvy to find out. But what does happen a lot is you'll be speaking to, let's say, the cousin of the person who passed away. And the cousin was maybe taking care of the guy who died. Maybe all the person's kids had abandoned him, didn't have anything to do with him, and the cousin was the one really, taking care of him. Well, if there's no will, that cousin is not going to get that property, because there's a hierarchy of who gets what. So usually it's the spouse, and then it's the children, and then it's the parents, and then it's the siblings. So the further you get removed in relationship, you want to do a little bit of extra question. You want to ask, you want to do a little extra investigation to find out that the person you're speaking with is actually going to be entitled to the property. Because again, you don't want to get the listing agreement. You don't want to do all this work and find out, Dave, the person you're speaking with, isn't going to inherit this property anyways. And that happens a lot. And sometimes people just don't know. Sometimes people, they think because they were living with him, they think because, they don't think there's any other living relatives that they're going to get the property. But if it's, if you're third, fourth, fifth removed cousin, you're probably not going to get it. So you want to ask, really, was there a will? Do you have a copy? And then what's your relationship to the person who passed away? Good? All good? Mm-hmm. All right. All right. So now this you've done the listing presentation. They're all good. You've determined probate is necessary. You've determined that you're speaking to the right person. Now you want to kind of this is where you want to show your knowledge a little bit, or at least stand out from the competition and actually close the deal, get the listing agreement. So I'll answer your question. So that one of the main question I always get, well, two main questions is, how long does probate take and how much does it cost? That's everybody's question. So how long does it take? It's like anything. You guys know, you're in a business where closing 30 days turns into closing 6 months later down the road. I mean, stuff happens. So if someone asks you how long can we close, you can give a range, but so much happens in between that you're gonna have some that close super fast, some that close a lot later. On average, though, just to hang your hat on something, I usually say probates last from start to finish around 5 to 6 months. That's in my office, that's kind of our internal goals is that, and when I say start, I mean, we filed everything. Not, the client hired us, but took a month to get us all the documents so we couldn't start. I mean, we got a case number from very beginning to the judge dismissed the case because it's closed. I try to, like I said, internal goal is around 5 to 6 months. But that's the probate in general. For you all as realtors, it's not that long, because on average, once we open the case, month 1, in 30 days, we try to get the personal representative appointed, which I talked about. That's the person who's in charge and able to sell the property. So by end of month 1, you've got a personal representative. And then usually around month 2 or month 3, I can ask the court for permission to sell the property. So when you're talking to the client and they're asking you how long, it's kind of a two answers is, well, the probate itself, you're going to be working with the attorney for about 5 to 6 months, but with me as the realtor, you're going to be working probably 1 to 3 months. And so in about 3 months, you'll be able to sell the property. Again.
You sell it, you put it under contract, not close it until the.
No, I mean
probate's
closing.
done. Oh, it's a closing.
I mean closing, yeah. And there's, again, I could go down a rabbit hole of like the legal part of it, but usually it's twofold. Depending on the stage of the case and then depending on when the person died and a couple other factors, the proceeds might be held in a restricted account for a while, all right, in the probate. So you all would get paid, you all would get your money, but the client might not get their money until month 6, but it depends. But you'll be able to sell the property and be done with it a little bit sooner.
So for us, between 2 and 3 months, it's a
Yeah,
safe
that's
timeline.
what I try to tell people. So I usually say, I usually tell realtors if a realtor refers something to us or they find a property and they say, when can we list this property? You generally want to wait. Go ahead and get the listing agreement, right? Like, get that person locked up, so they're not speaking to other realtors. But you can't really list that property until you have a personal representative appointed, because the personal representative is the person who can sell it.
Would that be the same person on name on the will as executor of the will?
It could be.
And
Yeah.
does it matter who signs the listing agreement?
Yeah, so I'll jump into that. So the listing agreement and the contract really need to say, let's just again use John Smith. So the listing agreement needs to say, because John Smith himself, he can't sell it. It's not his to sell. He's just acting on behalf of the estate. So when you get the listing agreement, it needs to say John Smith as proposed personal representative of the estate of whoever.
Not executor of the will.
He's not executor yet. When you go get the listing agreement, when you're going to John's house and you're talking to John and John wants to sell his dad's house, he's not the personal representative or executor
You
yet.
can't just say the estate of the deceased.
Well,
Is that-
because he's not so a probate hasn't been opened, right? So let's say again, in my example, I just die, my wife wants to sell the property, or my kid wants to sell the property, William comes to my house, no probate has been opened yet. So my kid can't sell the property yet. There's no probate. So he's going to have the kid sign it as himself, as the proposed personal representative of the estate. Now, so that's in the very beginning. And now, all right, so now you've got the listing agreement. Now the probate is opened, and now we get a personal representative. Now, my kid is now the personal representative. When you go under contract and you sign the contract, now the contract's going to be signed as John Smith as personal representative of the estate, because now he's been appointed personal representative.
So who can sign the listing agreement?
The person I just mentioned. So you can have whoever you want sign the listing agreement, but you want to make sure that you're speaking with the right person. So
Okay, all right.
And it doesn't have to be, it could be one personal representative and another executor of the will? You could have two.
no. The will is gonna, if there's a will, it's gonna say generally it's gonna say who the personal representative is, okay? And so then you're gonna use that person. So you can't have a will say one personal representative and then a miscellaneous personal representative. Does that make sense?
Yeah.
Yeah, so you're really, in the beginning, the listing agreement is the person who's going to be the personal representative.
Hopefully he will be.
And hopefully he will be. And then once he is appointed as personal representative, now when you sell the contract, now it's the personal representative.
Okay.
But yeah, that's the only really one thing is you want to make sure that you're and this is more so because you want to protect this person's interest. Because if you have this person, let's just say John, sign the contract as himself individually, one, he doesn't have the ability to sell the property, and two, if for whatever reason the contract falls through, the probate gets messed up, now you've got John on the hook and he's personally liable. And so you don't want him to be liable for the if the contract falls through. That's why you want to put language in there as personal representative. So he's only acting in capacity of the estate.
So what was the language you said proposed?
Yeah, so when you get the listing agreement, the person's name, John Smith, as proposed personal representative of the estate of the person's name who died. I know it's like a lot of language, it's a lot of words, but it's I'll send you guys more information as well.
But then he is responsible. He cannot back out of that contract.
Unless he's not appointed person representative.
Right.
No,
so
no,
that-
if he's the right person, like you're saying, he cannot, he's just like having the owner there.
Right, yeah, essentially, yeah.
Yeah, but that was that was a good question. If he's not appointed as the executor, then is the listing agreement still valid?
Well, if it's no, because he doesn't have the ability to sell the property. So it's kind of like if you find someone on the street and they say, hey, I want to sell, this property, and you're like, great, let's sell the property. You get a listing agreement and he's not the owner. I mean,
Right.
how are you you can't really enforce it because he doesn't even own the property. You as a realtor kind of got duped by him, essentially. So that's why I say in the beginning, you want to make sure you're speaking to the right person. Does that make sense? You look confused still.
No.
Okay.
I hear what you're
Yeah.
saying, but then there's also always a possibility of that person that we're talking to not being appointed as the executive.
Unless it was stated in the will.
Well,
And
you're
then
going.
you're safe.
You're go. What? So.
Right.
So yeah. So here's what I would do. Here's what I would. So I'll give you a real life example. So 2 weeks ago, I had a realtor. I didn't have a realtor, but there's a realtor who was knocking doors. Comes across a property. Okay. There was a woman in there, 75, 80 years old. She's cleaning out the property. He's talking to her. She tells him that her this actually happened to be a cousin. She said, my cousin just died. I'm cleaning out the property. It's like, okay, great. He didn't really know what to do. So he calls his broker, who knows me, sends him to me, and I say, okay, let me talk to because again, cousin that's really far removed. She might not be the right person. So I have a consultation with her. We go through our steps. I figure out she is actually entitled to sell the property. And so then I call this realtor and I say, hey, listen, she's the right person. You can get her the listing agreement. So you may want to, again, you can call me or call a probate attorney, whoever. But if you're finding a property and you're concerned that the person you're speaking with is not the right person, then yeah, you might want to. You can do your own research to figure out if it's the right person, but you might want to ask, a probate attorney to find out,
Or ask them if the property is under probate.
Yeah, or ask them. But in this case, the example that I just gave you, there was no probate,
Not
right?
yet.
Right. So I'm now, we're getting a bunch of information. We're going to start the probate. So there wasn't a probate when he found it. Okay, yeah. So we talked a little bit about the listing agreement, the sales contract. Just make sure, and again, your underwriter, your title company, they're probably not going to say this contract's not valid because they didn't sign it properly. This is really about protecting the client, because again, you don't want them. If John signs the contract as himself individually, and then for whatever reason the contract falls apart, he's now on the hook. You want the estate to be on the hook and not him personally. So that's really why you're being careful about the type of language on the listing and the sales contract. And then cost. So you asked about cost. It's like anything, you get what you pay for, and there's a range. So probate costs, I would say in general here in Miami-Dade, on average, are going to probably run between $3,000 to $10,000 on just a standard, probate. What we're talking about here.
Depends on the value of the property?
Some attorneys will charge a percentage. So there is a law that says you can charge up to 3% of the value of the. I personally don't do that, but sometimes there are attorneys who will charge 3%. Some will charge hourly. Some will charge a flat fee. It really depends. Some attorneys will get paid in the beginning. Some will get paid at closing. So that's why there's a big range. There's a big range as to costs. And so my preference is, from my perspective, I would prefer that if the realtor's going to send me something, I don't want the realtor to tell the client how much it's going to be, because it's kind of like if I send you a listing and I tell the buyer or the seller, oh yeah, but they'll do it for one commit, they'll do it for 1%, or whatever. You guys are going to be kind of screwed now when you go into that, and this person says, oh yeah, but the attorney told me you would do it for, and maybe you would have, but if it's an extremely complicated property, you might not want to do it. So again, price varies, from quality and from the type of case as well. So that's, so when you go, so I guess to kind of wrap up part 2, when you go in for your listing presentation, you don't need to tell them necessarily, the attorney's going to file the petition for administration, the affidavit of heirs, the petition for, all the legal jargon, that I know. You're just going to want to tell them enough. Like you're going to want to be able to, again, if you just ask, was there a will? What's your relationship? You're already, I think, demonstrating to the client that you're not just the run-of-the-mill realtor who just wants the listing. You're asking very poignant questions that I think will make you stand out. And then yes, you can answer if they want to say, how long is this going to take? You can say, well, in my experience, or in speaking with other attorneys, I think the probate is going to last around 5 to 6 months, but I think we'll be able to probably sell the property in 2 to 3 months. But I'm not an attorney, so you're going to want to cover yourself. You don't want to get locked into something and then they're pissed off at you guys or whoever. And then tell them a little bit about the process. One thing I would say about when you're going in for the listing presentation, probate by its nature, for you all, it's not that much more difficult. I mean, there's really, you might get caught up, in a legal battle in the sense that the attorneys are battling it, and you just have to manage the client as you have to manage your clients anyways. But it doesn't, work-wise, it doesn't really you don't have to do a whole lot more. The one thing, though, that I would say is different about these type of listings or, probate matters is probate by its nature, you're dealing with someone who's passed away. So you don't know the relationship. This might be, the daughter and her mom just died and they were extremely close, and now, the daughter can't keep up the mortgage. This was their family home, and she, so she's got to sell it. Obviously, selling a home can be an emotional thing, but now adding into there that you've got someone who just passed away, it makes it a little bit more complicated, or just more. I always, I think you have to go in there with a little bit more empathy than you would on a normal listing presentation. I mean, sure, sometimes you get someone who just like, I need the money. Let's get this thing sold, and it is what it is. But sometimes, this is a really difficult thing. This, again, could be the family home. It could be, that the person just died, so it's more difficult. So try to go in there with, I think, showing a little empathy goes a long way.
Hello? Yes.
Sorry, we'll continue. We'll just talk over. So how to market for probate property? So obviously, at the end of the day, it's about listings for you all. I think that it works for commercial and residential. I had one that I've been trying to get to William. Lady passed away. Has a really great property. Horrible lease agreement that makes the property not so great. But this works for commercial and for residential. I mean, it happens, common. In Miami-Dade alone, there's about 100 new probates filed every month. So not all of those are going to have properties. Not all of them are going to have properties, and sometimes, like our office right now, we have about 150 open probate cases. Not all of them have properties, and not all of them, sometimes, the people want to keep the property. They want to keep it as an investment. But still, there's a lot of opportunity there. And there's not, back in the day, you had, realtors who were short sale specialists, foreclosure specialists, and now they do have a certificate that is, probate certified, whatever. But there's not a lot of realtors who I think really market for this, for these type of properties. And I think there's a great niche. For me, I think your all's best referral sources are probably probate attorneys. I mean, I just think, you all can, again, there's a ton of attorneys, there's a ton of probate attorneys, there's a ton of, properties in each of these. So I would say go after probate attorneys as a start. You can buy lists. I mean, it's like anything, I'm sure you all have seen, you get solicited with, buy this list for expired listing or whatever. Like there are lists that you can buy, and those probably work. I mean, it's a numbers game. It's like marketing. If you send out, 1,000 emails, you're probably going to get 1 or 2, and of those 1 or 2, maybe you'll like turn it into one agreement. Yeah.
Can we talk about using the clerk of court's website to identify new probate cases?
Mm-hmm. There are ways that you can either go to the courthouse and they'll give you that information. I don't know that you could do it yourself online because I just know that there's not a way to search like all open probates.
Gotcha.
So you would have to either buy the list or you can go to the courthouse, and I think there's a way that they'll give you that information.
Or get some type of like tool to comb all the data.
Yeah.
Somehow.
So that's what a lot of people do. And I think that's great. The only thing I would say is if you do that, and I think I brought, okay, so this is like an email I get this guy, hopefully it's none of you all. But there's people who, they get these lists, and because I'm filing, 10 new probates a month, like I get hit up by a lot of realtors. And I don't think there's anything wrong with that. Like I solicit stuff. I have mass mailing lists. Like it's just part of the game. It's not the most cost effective, and it's whatever. I would say though, I can say it as an attorney, we are extremely picky and particular, and we're as part of our training and our nature, we are we pay close attention to grammar and style. And so when I get an email like this, which is it's not the worst. It's not the worst. It's not the worst. But you can tell it's an automated list. And I get, every time I open a new probate, I get the same exact style email from this person, and it's just kind of a crappy email. So
Generic.
Yeah, very generic. I mean, and also everyone has cash buyers. I mean, everybody. I mean, it's not. Maybe not everybody, but there are so many, like, that is, like, we have a cash buyer is not going to make, I think, most of us jump, right? I think, in South Florida, there's a lot of people who have.
So what's going to make you jump? When I pick up the phone and I call
No,
Justin.
so for me, what, I can only speak for me in particular, but I think, so I only do probate, right? So I don't do closings, I don't do title work. So once I get you all the new deed, I don't want to be CC'd on 50 emails from the title company, from both realtors, from the mortgage broker. I mean, you guys probably hate that too. But I try really hard to, my business, maybe it's a little bit different, but I don't give out my cell phone to clients or anything like that. Realtor I know is different, but man, like closings are non-stop. It's like, we need this now, we need this now, we need this now. And it's like, okay, but I gave, my job is done. I gave you the title, so I don't need to be, CC'd on all of that. I kind of look at the relationship with the realtor as kind of, we're kind of like a team. So again, going back to the example with the person who had been door knocking. I don't know him. I've never met him. I just happen to know his broker. And so the broker, he asked his broker and the broker called me. But I said, he said he had been working with the client, but he didn't know what to do about the probate. So I said, okay, let me call her, speak with her. She lives up in Tampa. I walked her through the process, and we just kind of kept in contact. And neither of us had signed up the client. He didn't have the listing agreement, and I didn't have the contract. So I thought he did a really good job of keeping me informed, and like both of us talking each other up along the way. And we both ultimately, I got the probate, and he got the listing agreement. So I thought that went really well. I think, again, you have to find, in anything you do, like it's my business as well. I am one of a lot of attorneys, right? I'm one of a lot of attorneys for who do probate. So when I'm, and I know generally when a potential client comes to me, they've probably spoken with 1 or 2 other people. And, their first question is going to be, how much does it cost, probably? And I'm not going to be the cheapest. So I have to find ways to give value to the client. And I think that's the same with your business. If you're soliciting not directly to the client, you're soliciting to the attorney. So what can you all offer? How can you make the attorney's job easier? Maybe you get some of that information, because I think in most people's mind, they prefer talking to a realtor than they do an attorney. I think just, maybe a common misconception.
Cheaper, that's for sure.
They
Less
think,
expensive.
well, right,
Less
they think it's cheaper. They're just more comfortable. Realtor's much more casual. So if for me, when I've got to get information from a client, again, we'll just keep using that same example. She's the cousin, so there's a lot of information. I need to know who was this guy's brothers, who was this guy's sister, and that will help my job in the beginning. So maybe you get some of that information from the client, and you say, hey, listen, I spoke with Susan. Her mother passed away in 2008. She had 3 children, and you've basically done a lot of the work for me when I go in. And I'm still probably going to have to ask those questions, but it makes me look good. So when I call Susan, I don't ask her the same thing over again. I go, hey, Susan, it looks like your mom passed in 2002. She had, So try to get as much information
Is
you
this
can.
a solicitous letter that you
Yeah,
got her?
yeah, I get that.
I
I get that
it
same
from my
one
house,
like
from my house,
every
yeah.
day almost.
Yeah.
So again, not to knock, well, kind of to knock this guy, but not to knock, mass email. I think they do work, and since you're, I'm sure you do a lot of that, but at least format it so it looks nice, right? Like you spent the time. I'm assuming this guy's paid money on something. Like he didn't or he spent time, trying to find me or whatever.
It's time.
Like,
Or
yeah,
he's
yeah.
totally,
It's
or
just
he's
time, yeah.
totally legitimate, and this is it.
Yeah, I mean, I just think if you're, for me, again, even if I'm going to send out, emails and whatnot, just try to make them somewhat personalized. So that would be one of my things. And then there's other professionals you guys can solicit, CPAs, financial advisors. But I think it's a great niche, and I'm happy to, I do other presentations on like just specific niche marketing. But if it's, something you all are interested in, happy to talk about it again. I think, so if you would, I meant to pass this around. If you guys would, just so I know who's here, and I'll send you all some, kind of free information more on probate, if you would write your name and email on here. And then if you have cards, I'm happy to, feel free to give me your card. I have just some, my cards here. Feel free to take these pamphlet on, on probate. And if you guys have any questions, yeah.
One thing you might want to speak to, one of the ones that I got, there were 2 people involved in the inheritance of this particular condo, and so we have to get an appraisal.
Yeah. Yeah.
Because they're not going to agree on it, and so what do we sell it for? So
Right.
had to get an appraisal.
Yeah, no, I think that's great.
Yeah, but I mean, that can happen many times. And this, maybe the bulk of the estate was out of state,
Mm-hmm.
but this particular condo was here.
Yeah, and that's one of the, I guess if you're thinking like another added bonus, I get a lot of referrals from out of state. So, Florida by its nature, there's a lot of people who have properties down here, but their children live elsewhere. And so that child doesn't know anybody. And so they might have come to me from either the internet or maybe just, a referral. So it's kind of tough. It's like I'm trying to, one, introduce myself to this person I've never met in person or whatnot, and now I got to bring in a realtor. So I think as the realtor, the more value you can provide to the client up front, make them feel comfortable, provide them with the CMAs and all that type of stuff at the outset will really, the truth is there's so many attorneys and there's so many realtors, but there's not a lot that really go the extra mile and really, can demonstrate a lot of value and care. So just by doing a couple like extra little things, I think you can really, it's an easy way to stand out. So if I don't have any other questions, that is it. I will, I'll, send this video to you all if you all want to watch it again, or send it to you guys if you want to circulate it through the brokerage. But thank you all. Appreciate it. Thank you all.
Thanks, man.